Okay, this was the question I was talking about with reference to that was asked in UPSC prelims 2021. With reference to India, consider the following statements. When a prisoner makes out a sufficient case, parole cannot be denied to such prisoner because it becomes a matter of his her right. And we discussed just now that parole is not a matter of right. It is a matter of discretion of the judge, because parole is granted to a person who is already convicted, okay, in special cases, okay, and he cannot be granted also. So it is completely based on the discretion of the judge. It is not a matter of right. तो फिर ऑप्शन क्या हो गया? ऑप्शन पहला हो गया false. Now second option is state governments have their own prisoners release on parole rules. So that is correct, because the management of prisons is a state issue. The management of prisons is a state issue, and every state has its own prisoner release manual and rules. So option 2 is the correct option. Okay, option 2 is the correct option. And see, that is why it is very important to read everything that is coming in the news. Okay, at least know the terms. Okay, at least if someone knew parole and bail, so they could have approached this question at least in the ratio of 50-50. You know? And if someone knew that the prisons are under state list, so they could have made an educated guess. Even if they did not know answer of the question, they could have marked answer 2 as correct. Okay. Now, the last topic that we are going to take today is sedition law in India. Okay. Why in news? A very interesting turn of events has taken place in the last week. Okay. What happened was, the first news, Supreme Court issues notice to center on plea challenging the sedition law. A plea was filed in Supreme Court which challenged the sedition law in India. Okay. It was filed by some journalists and a member of political party. Okay. And the petitioners claim that the sedition law infringes upon their right of freedom of speech and expression under Article 19(1)(a). Okay. So this was the challenge. After that, Supreme Court issued notice to the central government to reply. Now central government, what central government did was, central government in reply to that notice said that the sedition law in Supreme Court, they said that the sedition law is good in law and it does not needs to be reconsidered. Okay, so the Supreme Court should desist from reconsidering sedition law. It is good in law, it should exist. And after a few days, again, center, basically today or yesterday, on 9th of May or 10th of May, center has again replied to the Supreme Court and said that center is going to look into the law, and the center is aware of the concerns that have been raised by various sections of the society about the misuse and abuse of the law. Okay? And center is asking the Supreme Court to not invest its time in looking into this matter, and center has assured that they will look into the matter. Okay, basically what center is trying to say is that they are trying to, they being the legislature and the executive, they will try to look into the matter, okay, in an appropriate forum like parliament. The Supreme Court should desist from investing its time in the looking of sedition law. ठीक है, तो पहले क्या हुआ कि पहले अपोज किया सुप्रीम कोर्ट में किसी प्रकार की चेंज ना करो, फिर बाद में खुद ही सेंट्रल गवर्नमेंट ने कहा है कि वी आर गोइंग टू लुक इनटू द मैटर. तो what is sedition law? Claiming that it is fully cognizant of the various views being expressed on sedition law, the center told Supreme Court that it has decided to re-examine and reconsider the provisions of section 124A. IPC section 124A talks about sedition in India. Okay? actually it is under IPC, the whole IPC, ठीक है. IPC में chapter 5, I believe chapter 5, offenses against state, offenses against state, इस चैप्टर में IPC 124A mentioned है. IPC. Now IPC, Indian Penal Code, was accepted in 1860 and came into force in 1862. Okay, these are some important facts that we will be forming our whole this discussion upon. Center said that although there is concern of having a law that protects the sovereignty and integrity of the country, it is also aware of the abuse of the sedition law. ठीक है, fine. Now, what is sedition in India? So, sedition was basically formulated by Thomas Babington Macaulay. Thomas Babington Macaulay was the chairman of the first law commission, okay, in 1934. But it did not came into the original IPC. 1934 mein, the law commission was tasked with formation of Indian Penal Code, right? But it came with an IPC in actually 1834 में बना, 1852 के around it came into, they drafted, they presented their draft, but after some time, ठीक है, after like a decade, this IPC came into action. And one important point to note is the original IPC that came into action in 1872 did not have what this sedition law. ठीक है, it was a later edition, it was added later. ठीक है, so section 124A says that a person who commits the crime of sedition, a person commits the crime of sedition if he brings or attempts to bring hatred or contempt or excites or attempts to excite disaffection towards the government established by law in India. मतलब if someone by action, by writing, by any other measure of expression sorry, tries to bring about what disaffection or hatred or contempt towards the government established by law in India, he is said to have committed the crime of sedition. Okay, it can be either words, spoken or written, signs, visible representation or otherwise. Okay, it prescribes the maximum punishment of life imprisonment. Okay, so minimum punishment 3 years hai, maximum punishment is life imprisonment. The law of sedition was actually inserted in 1870. Okay, and its ambit was expanded in 1898 with a view to crush the freedom movement. The first person to have, the first major person to have convicted was Tilak, okay, Bal Gangadhar Tilak, for his seditious writings, so-called seditious writings. The person charged under this law is also barred from any kind of government job, and also his passport is seized. Okay, his passport is also seized. Now, constitutionality of the sedition law. Sedition law has been a very contentious law, and even Nehru said that it is better for us to get rid of this law as soon as possible, right? So it was not in Constitution of India. Sedition law is not in the Constitution of India, but yes, it has been adapted from the colonial Indian Penal Code that was implemented in 1862. So it is not in a constitution, but it is a part of IPC. Okay. So in 1955, Allahabad High Court in Ram Nandan versus State of UP found that the sedition law section 124 IPC is in violation of Article 19(1)(a). Now Article 19(1)(a) is freedom of speech and expression, right? Article 19(1)(a) is freedom of speech and expression. But important point to consider here is, and this statement is very important from the prelims point of view, okay, because in past also UPSC has asked what kind of restrictions can be imposed under certain fundamental rights. ठीक है? So what are the reasonable restrictions? So under 19(1)(a), what are the reasonable restrictions? The first one is sovereignty and integrity of India, security of state, friendly relations with foreign states, public order, decency and morality, and contempt of court, defamation, and incitement to an offense. That means speech is not absolutely protected. Okay, there are certain limits on free speech. ठीक है? So the restriction public order, ठीक है, was added later by the First Amendment of 1951 in order to meet the situation where Supreme Court said that in Ramesh Thapar case, Supreme Court said that the public order and sovereignty of the security of the state are two different things. ठीक है? Actually, public order was not present originally, only security of the state was present. So public order was, the violation of public order was not a original restriction on the freedom of speech, but to accommodate the Supreme Court judgment in 1951 in the Ramesh Thapar case, what what the government did was they brought about the First Amendment Act 1951 and they inserted the term public order, and now public order also became a reasonable restriction on the freedom of speech and expression. Okay, it is said that in the said case, Supreme Court opened. Okay, I told that already. Fine. So this is very important. We are going to look at the evolution of sedition law in India through the courts. Okay, in Ram Nandan versus State of UP, what happened was Allahabad High Court, basically, it was not a Supreme Court. Allahabad High Court found section 124 of A of IPC ultra vires to the Constitution of India via wide Article 19(1)(a). Okay? It said that IPC 124A is ultra vires to Article 19(1)(a) and hence it is constitutionally not valid. But this did not continue for a large amount of time. Now, the security of state in PUCL versus Union of India. Now again, why we are talking about security of state? Security of state is a reasonable restriction upon Article 19(1)(a), and in Ramesh Thapar case, we saw that the Supreme Court of India has made a clear distinction between public order and security of the state, and that is why we need to also understand what is basically security of state. So Supreme Court of India clearly defines security of state as serious and aggravated forms of public disorder, example rebellion, waging and hating or waging war against the state, okay, or insurrection. So only the speech which talks about such insurrection or anything, that does not amount to the violation of the security of state. Okay, a speech is protected. Okay, but if someone is waging war against India, so that is what that is not protected under Article 19(1)(a) or any under any fundamental right. Okay. But in 1962, Kedarnath Singh versus State of Bihar in Supreme Court, the Supreme Court upheld the sedition law. Allahabad High Court in Ram Nandan versus Union of UP, State of UP, what it found the section 124 ultra vires to the Constitution of India. But in Kedarnath is a very important, very important. It's like a landmark judgment in sedition law in India. So, but also Supreme Court basically upheld. Okay, upheld what? Section 124A. Okay. But it laid certain principles that should govern the application of sedition law on anyone. Okay. The government established by law is distinguished from the person who is running the carrying on the administration. Okay. So if someone is trying to criticize Prime Minister of India or Chief Minister of India, then he cannot be charged with what? Sedition law, because that person is not the government of India. The government of India is the state. If someone tries to incite violence against the state, then he can be charged with sedition. Okay. any act bringing a government into contempt or hatred, creating disaffection against it, would be within the penal statute. मतलब any act that brings hatred against the government, that can be considered the violation of, then that act is not protected again under the Constitution of India. ठीक है, तो मतलब section 124A can be applied there. Comments, however strongly worded, okay, expressing disapprobation of the actions of the government without exciting those feelings. Which feelings? Feeling of contempt or hatred or disaffection against the government cannot be considered violation of, cannot be considered a violation of sedition law. Matlab, if someone is criticizing government in very harsh terms, but that is in his speech, he is not using a term to bring about hatred against the state of the country. Basically, he is not trying to bring the hatred and discontent against the government, but against the policies, then he cannot be charged under section 124A. Okay. And also a citizen has a right to say or write whatever he likes about the government as long as he is not inciting violence. मतलब a speech not inciting violence is protected. Okay. So this was very important Kedarnath Singh judgment, and we already dealt with this. So I hope you understood the lectures today. If you have any doubts, any questions, any queries, kindly reach me out in the comment section. I'll be more than happy to take them. Thank you.